Okay, so this is part two of our video with Sandra from Lexity. We're talking about inheritance tax. I mean, there's just so much stuff about French taxes that we can't squeeze it into one video. So, Sandra, we're so glad to have you back. Please tell us when somebody is coming to France as an expat and they have assets or they have they pass away or their relatives pass away. How does the French tax system work when it comes to inheritance?
And French succession laws.
Exactly.
So inheritance taxes. It's a little bit complicated. We are lucky because France and the USA have signed a tax treaty on inheritance and gift tax, which is quite different from the usual treaty signed between France and the other country. Because in US, if you have the American citizenship, you will be liable in US. So you have a lot of disposition with the American citizenship. In principle, the assets are taxed in France in two major cases. When the deceased has his tax domicile in France, so he is a French tax resident, for assets located in France or outside France, or when the deceased is not a French tax resident, for assets located in France only. So that means only the assets localized in France will be taxed if you are a non-French tax resident, but maybe you have a home in France. However, the tax treaty provides a lot of exception to the principle of taxation in France, depending on several factors. The tax residence of the deceased under the international tax treaty. Because like I said before, you can be a French tax resident under French internal law, but also a US tax resident because of your nationality. So that means in this case, maybe under the international tax treaty, you will be considered like a US tax resident. We have to see the four conditions I gave you previously for under the tax treaty between France and US to determine the tax residency of a person. So the several factors, you have the tax residence, you have also the American citizenship. Like I said before, the tax treaty will introduce a lot of disposition when you are a US citizen, but also a French tax resident. You have a lot of your assets that will remain taxable in US. You have the type of assets held and the location of the assets, because in the US tax treaty on inheritance and gift tax, they say that the real estate, cash, tangible assets, company share, furniture located in the United States can be taxable only in the United States and can be benefit from a total credit tax in France. And you have also the number of months, years you have been in France. Why? Because in the tax treaty, we have a disposition that says that a person who's French tax resident under French law, but who is still considered a tax resident of United States because of his or her citizenship, be considered domiciled in the United States for the purpose of his or her estate if the two conditions are met. The transfer of residence to France must have taken place less than 5 years prior to the death. And the second condition is the person must have had the clear intention of retaining his or her domicile in the United States. So the second condition may be more complicated to prove, because that means you have to prove that you keep a residency, a home available in US. You come to US, I don't know, 4-6 months per year, but you have this disposition. It is essential to consult a professional to determine your specific situation, like I said, the place where your assets will be taxed, and also very important, the declarative obligation to be fulfilled in each country, because you can have like some tax credit in one country or tax credit in another country, because in any case, the tax treaty will avoid double taxation.
One of the items that I wanted to make sure we hit on, if somebody owns property in France, they're a resident in France, they bought a house in France. So let's say they bought a 700,000 euro home. It's in France, and they pass away. Like, so if Juliana owned a home, I pass away, and from what I understand, Julie would not get 100% of the house if I had children. And if there were stepchildren, there'd even be a different calculation. And so I want to make sure that people understand, if they're going to buy a home, how the inheritance process and procedure would work, and also make sure everybody is aware that if you're in the US and you're used to hearing about using a trust, they're looked as a tax avoidance scheme in France, so they don't recognize your trust. So let's go ahead.
Maybe I will give you like some 3 examples of taxation with the amount, and also with if you are French tax resident, if you are not French tax resident, but you have a real estate in France. So for example, maybe for the first, I have made 3 examples. So we have Diana and Charles. Diana and Charles are a married couple with 2 adult children called John and Patty. They have been French tax resident for more than 10 years. So in this example, assets are considered taxable in France, because like I said before, you have every situation is different. So it's best to check with a tax lawyer to be sure that these assets are taxable in US and these other assets are taxable in France. But for example, we say that all the assets are taxable in France. So Diana and Charles have joint asset of 1.6 million euros. I made the net value of the estate, because in fact in France for the estate you can take like some debts. I think it's the same for US. So let's say that we have like a debt of 50,000 euros for the mortgage of a home, for example. So we have a net value of estate 1.6 million. So in our case, you have in our case, unfortunately, Diana dies. Charles will get back the 800,000 euros corresponding to his own share, because it's joint assets. So Charles will just have his own assets, and he will also receive 200,000 euros, because Charles gets a quarter of the share of Diana. So that means of Diana shares of the 800 euros, Charles get a quarter, and the 2 children will receive 3/4 of the shares of Diana. So in our case, Charles will back the 800,000 euros. Charles gets a quarter of the share, and the 2 children will receive 3/4 of the shares. So that means in this case, Charles will receive 200,000 euros free of inheritance tax, because there is no inheritance tax between spouses in France. And each of the children will receive 300,000 euros. They are exempt for paying taxes on the first 100,000 euros each, and on the 200,000 euros, they will be subject to inheritance tax according to the scale bracket. So that means each of the children will pay approximately 37,000 euros of inheritance tax. In this case, you have also another possibilities, because in France you have the choice to have the spouse received a quarter of the shares and the other received 3/4 of the shares. But you have also the possibility that Charles received the usufruct of the estates of Diana, and his 2 children share the bare ownership. So in France, we have the usufruct and the bare ownership. The usufruct is the right to enjoy a property, so an asset like real estate or another assets, without being the owner and on conditions that is preserved, that is said maintained. So that means the usufruct can have the fruits of the property, but he is not the owner. And the other person, the bare ownership, has the right to sell the property, but may neither use the benefits. So that means the usufruct the usufructier will receive all the benefits from the usufruct, and the bare ownership will be the owner of the property. It's a little bit complicated, but it's called in France dismemberment of property rights, démembrement de propriété. So in this case, Charles and his children will be joint owner of all the assets, because Charles will receive usufruct and the children will receive bare ownership. So that means, for example, of an investment account. So it's a little bit complicated because they have both not the property, but they have both the possibility to share the assets. And the advantage is that when Charles dies, the two children will recover his usufruct share without paying inheritance tax.
Oh, okay. Now that's interesting.
What if he had a stepchild with Diana, and so he had the two regular children from him, and he had a stepchild from Diana? How does that stepchild get treated?
Let's say that Charles has a stepchild and Diana is the mother. So
Right.
that's mean when at the time of the death of Diana, this child will receive the same amount of his brother or sister because he is the child of Diana, so no problem. At the death of Charles, because the Charles has some common assets with Diana, the child will receive a part of the assets of Charles. But very important, he is not the child of Charles. So that means he has not the same right for taxation to the brother, to the half brother or sister. So that means in this case, he can pay 60% of taxation on the assets he received. But you have the possibility for Charles to make a simple adoption to the child. So that means in this case, the child will have a mother, a father, a stepdad, but we have a simple adoption. So the possibility to have the same rights to his brother and sisters in the estate of Charles with the same taxation.
Yeah, so I just want to make sure it was clear for anybody that's looking at going to France that if you have stepchildren, that the inheritance will go different. Your natural children will have about a 20% tax rate, where your stepchild is going to be taxed at 60%.
Yes,
and so there's
no relation. Yes, there is no relation. Yes. Unless you have a simple adoption, it's a possibility.
I wanted to make sure that it's clear for everyone for the usufruct. Usufruct is not only your real estate, it's also your additional assets, liquid assets, everything.
Yes, usufruct, that means just you have the benefits of an asset. It's not just a property. So that means if Charles and Diana has, I don't know, an investment account of, let's say, 1 million euros and a house of 600,000 euros in our example. If Charles decides to have the usufruct of the estate of Diana, he will receive usufruct of the part of the home, but also the usufruct of the investment account. So in his cases, he can receive dividends, interest of this account, but he cannot sell this investment account because only the bare ownership has the right to sell. So that means the bare ownership is the owner of the investment account, but Charles can have all the benefits of this account. That means dividend, interest, capital gains. He can receive all the benefits of this account, investment account.
Okay, and I understand there's also something called an Tontine clause when you buy a home.
Yes, Tontine clause. So it's a specific clause, but for me, it's not the best way to optimize the estate. Why? Because Tontine clause, in fact, you say that you buy a home with your Diana and Charles buy a home. At the time of the death of Diana, Charles will be considered like the only owner of the home at the beginning of the purchase. So that means like Diana doesn't exist on the paper for the home. But you have some possibilities that you have to pay taxes in France on real estate, notary's fees, because in fact, in France, when you buy a home, you have something called notary's fees, but also like taxes on real estate. It's approximately 8% of the amount of the real estate. That means you have a possibility that with the Tontine clause, you are considered like the real owner at the beginning, but you can have to pay the real estate taxation on 8% of the value of the property. It's not very clear, so it's not my recommendation. It's not also my recommendation because, in fact, as if you made if you buy the home with your partner's spouse, you will receive automatically a part tax-free. So that means you don't have to make a Tontine clause. A Tontine clause, it's just like for not spouse, but like partner. It's a little bit different. For me, it's not the best way to optimize the estate because you cannot make a Tontine clause with your children. You will have the same results. And you made the Tontine clause with your spouse. But like I said before, you don't have any taxation between spouse in France, any inheritance taxes between spouse. So that means I'm not sure that Tontine clause is very interesting for people.
That's interesting. Thank you for clarifying that because I know there's a lot of people out there trying to understand in Tontine. Wow, there's a lot of complications in French law.
Yes, unfortunately, it's complicated in French law.
I'm not sure if they can see us when the slide's up, so I don't know if we want to keep the slide up all the time.
Yes, I have another example just with an alternative of inheritance tax. For example, if Diana and Charles had optimized their assets and had opened life insurance policy for each of their children to the value of 152,000 euros, which they had financed with their own money, it will be better. Why? Because insurance policy worth less than 152,000 euros, whose contribution were paid before the policy's holder's 70th birthday, are not included in the estate and are exempt for inheritance taxes. So that means in this example, if you have the same joint asset, but you have like 2 life insurance policy for parties and 2 life insurance policy for Johns, one contracted by Diana and one contracted by Charles, the net value of the estate will be less because you are not because the life insurance policy are not in the estate. So that means the net value of the estate will be less than 1 million euros. And you have the better distribution to the earth. Charles will receive the part of the estate shall will receive their own share, since all property is jointly owned. So that means shall will receive 595,000 euros. He will receive also a quarter of full ownership of Diana's share. So in my example, almost 124 euros. But John and Patty will receive more and pay less taxes. Why? Because John and Patty will receive with inheritance tax 187k euros approximately, and they will pay taxes inheritance of 14k euros versus 37k euros in my first example. And they will also receive life insurance for 152,500 euros. So it will be better because they will receive more than in my first example and pay less taxes in France. So it will be a good alternative to put in life insurance, but it's very important to put in life insurance before your 70th birthday, because after the rules are different. Also, it's very important, but you have also possibilities for limiting the amount of your inheritance, like in example with life insurance, but also with dismemberment of the property. Like I said before, it's a possibility that you can give the bare ownership of your property to your children. So before moving to France, my recommendation will be to consult your US advisors and lawyers in France, so that can you make the best possible arrangement to limit the taxation in France. Or if you have, like, for example, a real estate in France, we have, like I said, the dismemberment of property. So that means you have the usufruct and the bare ownership, but the advantage is you give to your children while you're alive the bare ownership of the property. We have a tax, we have a scale bracket depending on the age of the donor in our case. So for example, if you are 50 years, you will have to pay 50%. You can give the bare ownership of your property, and your heir will pay only 50% of the value for the donation. So that means the inheritance taxes will be only for the 50. I'm not sure I'm clear. I'm sorry.
No, I think so.
Maybe it's too complicated to sum up. If the donor is 50 years, he can give the bare ownership of 1 or 2 children, and the children will pay only 50% of the value of the house because of the age of the donor. It's 50%. And in this case, it can be very advantageous because, for example, if you give, 1 million, so that means you have to pay inheritance taxes on 500,000 euros. But at the time of the death, the usufruct will extinguish automatically, and the bare ownership will become the full ownership of the property without paying inheritance taxes. So it's a possibility to optimize the taxation, but all the situation is different, and I have to study to be sure that it's possible. But you can give some assets before moving to France, or if you are already moved to France, or if you have buy a property or assets in France, you can make some dismemberment of property to avoid to pay highest taxation at the time of the death.
Okay. Wow.
Okay, it's a lot to swallow.
It's I'm sorry, it may be a little bit complicated, but taxation is very complicated. And I have another example, but we have the case of Diana and Charles, or the same case, but they are not French tax resident, they are US tax resident, but they own a common property in France for 1 million. The net value of the estate is 1 million, and you have to pay taxes in France because the property is located in France. So that means in this case, Charles will receive this own share. So he will receive 500,000 euros. He will also receive a quarter of full ownership of Diana's share, so 125,000 euros. And John and Patty will receive the third of quarter of full ownership of Diana's share. So that means they will receive approximately 190k euros, and they will pay inheritance tax at the rate of, they will pay inheritance tax for 14k euros. In this case, in principle, John and Patty will be also taxable in US because because their parents are US tax residents. So that means they will receive the tax credit in US equal to the tax paid in France. But they have to file taxes, they have to file form in France, and they have to file from in US and ask for the tax credit. It's complicated.
And the whole situation there with the inheritance, it's going to be complicated. So if you're going to go to France, if you're already in France even, make sure you're reaching out to us so we can get a hold of Sandra for you, or you can email us at warrenjulietravel@gmail.com, and we'll shoot your email directly over to Sandra. That's probably the easiest and simplest way to get direct communication with her. This is pretty esoteric stuff. This isn't something that anybody or everybody on Facebook is going to know when you're out there talking to groups. I will tell you, our head was spinning with so many different things we're hearing from people about inheritance and different scenarios, and it is complicated. I wish I could say that it's French taxes made easy in this video, but it's going to be very nuanced, and I think really having somebody, especially if you have assets, working for you in France, or that you're getting these questions answered beforehand, is going to be very important. Don't jump in blindly, especially if you are a person that has much of a net worth. If you don't have a large estate, or you don't have children, or if you don't have somebody outside of your spouse, it's probably not going to be very complicated for you. But it comes down to when your estate gets larger, or if you have children in the mix, it becomes much more complicated as far as inheritance. And so I'm really glad we're having this conversation, because it's clarifying, but I'm sure we're going to go to bed tonight and have a lot of time that we're going to be scratching our heads and having other side conversations, just like you guys watching, which means you're going to probably want to call or email Sandra. So please make sure you reach out. Also, don't forget to go to our Facebook group, Warren Julie Travel, and also our website, warrenjulietravel.com, and there you've got all kinds of expat and traveler resources, as well as international health insurance information. So make sure you go there. Even if you're looking for French health insurance, if you didn't watch that video, we have a link there to send you over to our French insurance guy. But if you're anywhere else in the world, I can handle you with the other companies I represent. So until next time, have a great day, everybody. Bye-bye.
Ciao.